My name is Jason Rosenberg, and I'm a partner in Alston & Bird's IP, Trademark, and Copyright Group. Our group is represented in 9 offices, coast to coast, and we're a full-service trademark and copyright team, handling both litigation and enforcement, as well as trademark clearance, registration, and counseling. We work with our clients on both their important established brands, as well as assisting them with new initiatives. Today I want to talk about some of the key considerations to think about before sending a cease and desist letter. Dealing with trademark infringers is part of doing business, especially for companies with well-known, important, and valuable trademarks. If you see an infringement, you're going to want it stopped, and you're going to want it stopped today. But before sending that cease and desist letter, and certainly before initiating a trademark proceeding, certainly before filing litigation, take a moment and step back and think about the situation as a whole. Doing so can not only save you a tremendous amount of time and money in the future, but could be critical in protecting your own rights in your own trademark. Before sending the cease and desist letter, make sure your own trademark house is in order. For instance, if you have a federal trademark registration that covers dozens of goods and services, make sure you're actually using the mark on all those goods and services, especially the ones at issue in the infringement, before sending the letter. This is especially true if you recently renewed your mark and have submitted a sworn declaration of use to the trademark office. The last thing you want is for the infringer to be able to have your mark declared invalid or even fraudulent. And while it may sound obvious, think twice before sending the letter if there is any question as to whether you are truly the first user of the mark for the relevant goods and services. Surprisingly, we sometimes see others send letters alleging infringement, and it turns out that they're not even the senior user of the mark. When that happens, the arguments have essentially been flipped, and the brand owner has basically laid out the case for trademark infringement against themselves. So if there's any question as to who is the first user of the mark, or it's a close call, consider whether a more robust investigation is necessary before you send that enforcement letter. Next, know your adversary and its trademark. Not all adversaries are created equal. It goes without saying that going after a Fortune 100 company is different than going after a smaller operation with fewer resources. Brand owners need to carefully consider the adversary and its trademark before sending the letter. Knowing the answers to some key questions such as, how long have they been using the mark? What sort of enforcement efforts have they initiated on their own? Is the mark the name of the company or a key product offering, or is it something smaller and more recent? Knowing the answers to these questions is critical before deciding on an enforcement strategy. The time to think about your next steps is before you send the initial cease and desist letter. In other words, think a few chess moves ahead. Not all instances of infringement need to result in litigation. But before you send the letter, consider what you'll do if you don't receive any response at all, or if the infringer refuses to comply with all of your demands. A trademark owner doesn't have to go after every instance of infringement, but it can't sit idly by and allow consumer confusion to occur. Unfortunately, some trademark owners prefer to send the letter first and put off any substantive discussion about what happens next, or even the true merits of the matter. That can prove to be a grave error, especially if it results in a declaratory judgment action for non-infringement being filed against you. Finally, all cease and desist letters are not created equal. Sometimes we're asked what form we used for our cease and desist letters. Fact is, an effective letter never comes from a form. You need to take the individual circumstances into account, many of which I've mentioned here today, and carefully consider the wording and the tone of your letter, as well as your demands. These days, you should expect that any letter you write is going to end up being posted on the internet. Overreaching, overly aggressive, and threatening letters are almost never as effective as a letter that's carefully tailored to the situation at hand. For instance, the letter you write to a small mom-and-pop operation in a distant location who may be unaware of your rights is not the same letter you'd write to a direct competitor who's using the same or a similar mark, and neither of those are the same letter you'd send to an outright counterfeiter. Finally, take a hard look in the mirror and consider the strength and recognition of your own brand before sending that letter. The fact that you may be the biggest name in plumbing supplies doesn't necessarily mean you're going to be able to stop someone from using the same or similar mark in connection with retail services. A good trademark lawyer can help you understand the strengths and weaknesses of your position and help tailor your trademark enforcement strategy accordingly. At Alston & Bird, we can help you understand the strengths and weaknesses of your position and help you develop a trademark enforcement strategy in light of your position in the marketplace.